Good afternoon. My name is Kayla Hinton, and I have chosen case 6 for my final presentation project. I will be going through my slides, so please join along with me. The general gist of case 6 is that John Arnett, truck driver for Saga Food Services, is disputing a claim with the union's help that he does indeed deserve holiday pay. So the labor issue at contention pertains to work requirements for holiday pay in a unionized business, which is important to note. The discrepancy is based upon two seemingly conflicting statutes in the contract provisions, and to date, the union has filed a grievance on behalf of John, claiming that all requirements have indeed been fulfilled by the collective bargaining agreement that stands to date, signed by John, the union, and me as standing. As the director of HR, I have my first loyalty to Saga Food Services as a business unit. Because Saga Food Services is unionized, I'm not just responsible for employees based upon company policy. I do have to engage with the union with company policy and our collective bargaining agreement in mind, which is very important to note because there is two sets of rules, not just one. My main role in this specific situation is to determine if John Arnett has failed to meet any of the holiday pay requirements as set out in the collective bargaining agreement. A little bit of background on the case is that John Arnett is a truck driver for Saga Food Services. He has a normal business work week of 4 10-hour workdays. Company policy specifically states that if an employee is not scheduled on a holiday, they are allowed to then observe said holiday the next business day. Part of this stipulation, though, is that they must work their first scheduled shift immediately before and after the company holiday observation in order to actually receive holiday pay. John was not scheduled on Monday, Labor Day, so he was able to observe the holiday on Tuesday. However, John then, late at night on Tuesday, decided to call in and take a personal holiday on Wednesday, though it was not approved by a manager. In this situation, John was technically okay because of precedent, where if you called in an hour and a half before your shift, then they typically would allow you to take off and without any repercussion. So as the discrepancy for this case, Saga Food Services is truly denying John holiday pay, claiming that he did not fulfill the policy requirements as set out in the collective bargaining agreement. The two company policies in question are Section 7.3b, which states that employees must work their scheduled shifts immediately before and after an observed holiday to receive pay, except for proven sickness or injury. In this case, John did work his immediately scheduled shift before his the day off, but he did not work the day after. That is Wednesday. So technically, this is where Saga Foods is saying that he broke contract. On the union side and John's side, they are saying that because he did observe Section 23.06, which says employees are allowed 4 personal days per contract year, that he is not in breach of contract. They're saying that because he did follow this and his days are allowed, that therefore, because they're allowed, he is then allowed to take them whenever he would like to, that Saga Food Services cannot dictate that. So this is a discrepancy because both statutes are laid out in the bylaws. So there is some leeway here, though, with Saga. And as the director of HR, after doing some research, I would stand to say that though John did have precedence in not getting management approval for a personal day by giving notice in time, the contract states that prior approval is needed for qualification as pay. So on a technicality, they could actually prosecute this, even though there is precedent, because contracts are binding. John was within bounds for taking one of his personal days. However, he violated the holiday pay part of the contract because he specifically did not work the immediately scheduled shift after holiday observation. And from my perspective as the director of HR and after consulting legal journals and past cases, I would say that violating one section of a contract is enough to disqualify the rest of the contract, even if other requirements are met. So my specific question in case 6, which is question 1, says, how would you present your case that John Arnett is not entitled to his holiday pay for Labor Day? I would say that precedent is good, contract is binding, end of story. Personal days are a generalized contract provision, while holiday pay is a specific clause with distinctive requirements that overrule an otherwise accepted clause, basically stating, yes, you are allowed to take personal days. They're provided for, you get paid. That is a healthy labor law. However, there is a special case whenever holidays are in play because they are special different work days with different pay and different regulations as set out in a contract that was signed by John, that you have to work the scheduled shift before and after. This is for the company's protection so they don't lose money or business, but also so that they're not overpaying or being taken advantage of by employees who want to add on extra long vacations while getting paid. So my immediate stance is that by taking a personal day after an observed holiday, John did not meet the requirement to actually get paid for the holiday, which is unfortunate for John. However, he did know that this was in the company policy because he signed off on it. Some of my supporting research through different journals on law and collective bargaining agreements state that collective bargaining agreements are an accepted industry wage setting instrument. Collective bargaining is about the well-being of an entire entity, employees being an extension of it. So we have to look at the general gist of how a company would benefit or not benefit from a collective bargaining agreement. And in this case, the whole business would suffer more if the holiday pay was extended. So John falls underneath that. Holiday pay is law. However, employers are allowed stipulations in such cases as John violating part of the contract. If the employee signed under a contract, then the stipulations of that contract are binding. End of story. It is a legally upheld in court binding document. So the union can try and fight it. However, it's not likely that it would pass. Within contract law, there is both explicit and understood freedom for employers to make those judgment calls, and employers have the right to withhold pay from an employee who has not met requirements as set out in a contract agreement. As the HR director, I recommend that John not be paid, and because it is under the management right clause. There's no further action needed to be taken with John, but should John or the union take legal action, Saga Food is prepared to go to court, as paying in this instance would create precedent for future cases. In conclusion, the information provided, John is a good employee who did not realize that one clause can negate another in a contract based upon its nature and stipulations, and the only repercussion from this discrepancy is that John will not be receiving holiday pay.